A new statement has shifted the focus of the five-death investigation near Pattaya. On August 3, police brought 24-year-old Chatchanan Paeniam, known as Fluke, from detention for further questioning at Na Jom Tien police station. His account does not settle the case, but it gives investigators a new version to test against phone records, vehicle movements, witness testimony, and physical evidence. The immediate question is not whether the statement sounds convincing. It is whether independent evidence can confirm where he was, what he knew, and what actions he personally took. The questioning lasted about an hour and was led by a senior Chonburi provincial investigator after permission was obtained from Pattaya Provincial Court. Suksan Misajan, president of the Pattaya Lawyers Council, attended under Thailand's criminal procedure safeguards. Reports say Fluke asked to provide an additional statement voluntarily after investigators identified issues they still wanted clarified. Because he was already under a court detention order, police could not simply move him informally. Reports say the authorities followed the required process to question him and then return him to custody. According to his lawyer and multiple Thai reports, Fluke accepted involvement only in the case concerning a Thai father, mother, and daughter. He denied knowing about the separate killings of two Russian siblings and denied knowledge of reports suggesting more victims. Those are the suspect's claims, not findings of fact. And police say every part of the account still has to be checked. The distinction is crucial for a legally safe report. Acknowledging what a suspect said is not the same as accepting his account or assigning responsibility to the other accused men. Fluke reportedly claimed that he had been misled about why he was being taken to the family's home, and later acted because he feared the other suspects. He said he initially believed he was going to help control or detain someone, and he claimed he did not know in advance that killings would occur. Police have not publicly confirmed that version, and the question of what he knew, when he knew it, and what he did remains central to the investigation. His reported apology to the victims' relatives and his description of fear are part of his account. Neither substitutes for evidence about planning, presence, or conduct. The public record is more specific about several movements investigators are examining. Reports say Fluke gave partial information about travel to the victim's property, moving vehicles, and the use of property after the deaths. His lawyer declined to reveal details involving telephone signals, routes, and locations because they are part of the evidence file. That restraint matters. The case will turn on corroboration, not on the most dramatic account given outside court. Digital location records may show where a device traveled, but investigators must still establish who possessed it and how that movement relates to other evidence. Police have charged Fluke with jointly committing premeditated murder. Investigators are also considering further charges connected to property and conduct after the incident, according to local reporting. A charge is an accusation, not a conviction, and the final legal outcome belongs to the court. His lawyer said a confession or cooperation may be considered, but it does not automatically produce a reduced sentence. Thailand's courts will assess the admissible evidence, each defendant's alleged role, and any legal arguments raised by the defense. Media descriptions cannot determine the sentence. The August 3 interview came after a wider investigation that began with two missing Russian siblings and then led police to a concealed burial site in Huai Yai, Banglamung. Evidence from that inquiry was later linked to a second grave containing three members of a Thai family who had previously been reported missing. Police have described links among suspects, vehicles, and property as the breakthrough connecting the cases, but the full evidence has not been released. Although the cases are now discussed together, investigators and editors should keep the victims, alleged acts, and supporting evidence for each case clearly separated. The Thai family's relatives have also challenged how they were kept informed while the three were missing. Chonburi and Huai Yai police apologized for communication failures and promised more regular updates in future missing person investigations. Officers said they had continued working the case, while acknowledging that the family received too little information. That dispute is separate from guilt, but it is an important public safety question about how missing person cases are handled. Police said early clues supported several possible explanations. but those investigative possibilities were not conclusions and should not be used to blame the missing family. Fluke's new statement also pushes back against rumors that the known 5 deaths had already expanded to 7. His lawyer said Fluke claimed knowledge only of the Thai family case and denied knowing of any additional victims. That does not prove there are no other cases, but it means the widely circulated number has not been confirmed through this interview. Editors should avoid presenting any higher total as established fact unless police announce evidence. The same caution applies to social media claims about motives, police protection, and unnamed accomplices. Those allegations require official evidence or clear. After questioning, authorities returned Fluke to custody under the existing court order. Separate reports say the other named suspects were being held under heightened observation at Pattaya Special Prison, with co-defendants separated and staff monitoring possible risks. Reports differ on whether the intake isolation period was 5 or 7 days, and on whether 3 or 4 suspects were already inside at particular times, likely reflecting different reporting times. Those details need confirmation before appearing on screen. The stable point across reports is that officials described enhanced monitoring and separation while the suspects remain in pretrial detention. Prison authorities separately said the principal suspect, Thanakothong, known as Pong, had no recorded history of psychiatric treatment in the prison system. They also cited a prior violent incident in custody and said security precautions had therefore been increased. That information describes custody management only. It does not establish mental state at the time of the alleged offenses, and it should not be used to diagnose or speculate. A previous conviction or prison disciplinary history also does not prove the current allegations. It is relevant here only because prison officials used it to explain their present security assessment. The next decisive step is verification. Investigators can compare Fluke's account with telephone location data, CCTV, vehicle records, property evidence, witness statements, and the statements of the other suspects. Any contradictions may affect charging decisions and the credibility of each account. Until prosecutors and the court test the evidence, claims of coercion, prior knowledge, and individual roles remain allegations under investigation. Viewers should watch for confirmed milestones, forensic results, additional charges, a formal prosecution decision, court hearings, or a documented police statement resolving disputed details. For residents and viewers, the confirmed update is narrow but significant. A suspect has given an additional statement, limited his claimed involvement to one of the 2 known cases, and offered an explanation that police have not yet validated. The investigation remains active, no court has decided guilt, and rumors of additional victims remain unconfirmed. The safest conclusion this morning is that the story has moved from discovery and arrest into the slower work of testing accounts against evidence. That process may produce major new facts, but until it does, the responsible headline is about the new statement and the verification now underway, not a claim of guilt beyond what the court has established.